Hello and welcome back to our channel Travel and Jobs. We hope you are doing great. Today, we will talk about the UK reentry bans, that is the 1 year, 2, 5 and 10 years reentry bans in the UK. We will let you know what it's all about, what each of the bans entails, why UK reentry bans are issued, how to remove them, exceptions to reentry bans and applying for a UK visa after a reentry ban. Before we continue, we made a video about how to search for UK visa sponsorship jobs 3 days back and someone guided by our videos successfully got a job here in the UK. Congratulations to him. That video will be linked at the end of this video and in the description. So do well to check it out and to check out other videos. Also make sure you subscribe to our channel. What is UK reentry ban? A UK reentry ban means that a person is unable to return to the UK and will not be permitted entry at the border for a specified amount of time. Reentry bans last for between 1 and 10 years, depending on the reason for the ban. They are issued to migrants who have breached the immigration rules or used deception when making an immigration application. If you are refused entry to the UK, any new visa application you submit to the Home Office will be refused, and you will be turned away at the UK border if you travel here. Why are UK reentry ban issued? UK reentry bans are issued for a number of common reasons. The Home Office imposes entry bans where they believe that individuals have breached immigration law or they have used some form of deception when applying for a visa. Some of the examples include overstaying in the UK beyond the expiry date of your visa, coming to the UK illegally, breaching the conditions attached to a visa, providing false documents or information in a visa or other immigration application. UK reentry ban periods. The length of any reentry ban is determined by a range of factors, including the immigration rules that were breached, whether the individual left the UK voluntarily, whether they were deported, and at whose expense. For example, no reentry ban will apply if the person overstays for 30 days but leaves the UK voluntarily at their own cost. A person who left the UK voluntarily at their own expense after a longer period of overstaying and breached their visa conditions or used deception in their application will be subject to a re-entry ban of 12 months. If the Home Office paid for their departure, this would lead to a re-entry ban of 2 or 5 years. The 2-year re-entry period would apply if they left within 6 months of being given notice of their liability for removal by the Home Office, or 5 years if after 6 months. A person who is removed or deported from the UK or used some form of deception, i.e., lied, when applying for a visa will typically receive a 10-year re-entry ban. Re-entry bans normally start from the date that the individual departs the UK or the date of the refusal of an application where deception was used, and this can lead to a re-entry ban of 10 years. How to remove a UK re-entry ban? It may be possible to remove or challenge a re-entry ban in limited circumstances, including where an exception applies that means you should not have received a re-entry ban. There are human rights or compelling reasons to lift a re-entry ban. The re-entry ban was unlawful, judicial review. Exceptions to re-entry bans. There are certain circumstances under which a person should not be issued with a UK re-entry ban, including where the individual breached the immigration rules when they were a child, overstayed after a decision to refuse an application, or cancellation of permission, and this was later withdrawn, quashed, or reconsidered by the courts or a tribunal. Overstayed, but they made an application within 14 days of their leave expiring, and the Secretary of State believes that there was a good reason outside the control of the applicant as to why the application could not be made in time. Applies for entry clearance as a family member. Did not know that the documents they submitted or the information they provided were false. Is a victim of human trafficking. Applying for a UK visa after a re-entry ban. In most cases, once the period of the re-entry ban UK has been completed, a person can then apply for a new visa to come to the UK, example, applying for a visa after a 1, 2, or 5-year ban. Where a person received a 10-year re-entry ban, they may be refused entry or leave, i.e., if applying for a UK visa after a 10-year ban, even after the ban period is completed if the Secretary of State personally directed they be excluded from the UK. They received an exclusion order or a deportation order. This is because a person who is subject to an exclusion or deportation order cannot enter the UK regardless of any re-entry ban period being completed. Thanks for watching and subscribe to our channel for more immigration news daily. We will see you in our next video.